Hello, everyone. My name is Nina Halatova, and I am a lawyer and project coordinator at the Community Legal Education Association, or CLEA, located in Winnipeg, Manitoba. CLEA is a not-for-profit organization that offers legal education, information, and other resources across the province. Today's presentation is going to be part 3 of 3 in a series of presentations about family law in Manitoba. We're going to be discussing spousal support and common law partner support, property division, as well as protection and prevention orders. The contents of today's presentation are for general information only and do not constitute legal advice. If you do require legal information about your specific situation and you don't have a lawyer, you can feel free to contact our law phone-in program for free legal information. With that being said, let's jump right in. Okay, let's start with spousal support. So if I say spousal support, keep in mind that I'm also referring to common law partner support. And if I say marriage or spouses, I'm also referring to common law relationships, because the laws about this apply to married couples and common law couples in the same way. Common law partners can seek spousal support as a remedy if they've been living together for at least 3 years or for 1 year and they have a child together. In Canada, we have the Spousal Support Advisory Guidelines, which give us some suggestions of appropriate ranges of support in a variety of situations for spouses who are entitled to support. The guidelines don't deal with entitlement, though, so before you start trying to figure out dollar amounts, you have to first determine whether your situation actually entitles you to receive support in the first place. It can sometimes be hard for couples going through a separation or a divorce to agree on spousal support. And this is because, as I said, the guidelines give us a range that may be appropriate rather than an exact dollar amount. So on one hand, you may have someone who is seeking spousal support who may very well be entitled to it and may need it to be able to meet their needs. And on the other side, you might have someone who is very much trying to reduce their spousal support obligation as much as possible, if not trying to avoid paying spousal support altogether. So first, let's talk about the 3 situations in which someone may be entitled to receive spousal support. Compensatory spousal support is intended to compensate a spouse for any economic disadvantage suffered as a result of the marriage or the role that they took on in that marriage, or as a result of the breakdown of the marriage. For example, if one spouse takes a step back from their career to be a stay-at-home parent or homemaker, and that results in a reduction of their earning capacity, they may be entitled to compensatory support. Of course, the longer that someone has been out of the workforce, the more pronounced this may be. The second category of support is non-compensatory, and this is more about helping someone meet their basic needs and improve their standard of living post-separation. So in this case, it doesn't have anything to do with the role that someone took on during the course of the relationship. They may very well have been gainfully employed throughout the course of the relationship, but there may be a significant difference in incomes between the two parties. After separation, one spouse's standard of living may significantly decline from what they had enjoyed during the course of the marriage, so the law says that spousal support can be ordered in these cases in order to sort of balance things out. And lastly, we have contractual spousal support, and this is support that parties agree to in a contract, like a cohabitation agreement or a prenuptial or postnuptial agreement. It's most common in these types of agreements to see people opting out of spousal support or contracting out of it, but sometimes you do see people set out either an amount of support or a mechanism for calculating it or something similar. Next, let's go over how spousal support is calculated. So again, the spousal support guidelines give us a range. Firstly, for quantum, or how much support should be paid, i.e. a dollar amount. And secondly, for duration, or how long that support should be paid for. The quantum or dollar amount is calculated based on the income of both parties and the length of the relationship. And it's different depending on whether or not there are children of the relationship. So just pulling some numbers out of thin air, you might see a low-end amount of $500 a month, a high-end amount, let's say of $1,500 a month, and a mid-range of $1,000. Duration of spousal support is then going to be based on the length of the relationship, with half a year to 1 year of support for each year of the relationship. So if my partner and I have been together for 10 years, one of us may be entitled from 5 to 10 years of support. To do the calculation for quantum, there's a formula, and actually there are two different formulas depending on whether child support is or isn't a part of the picture, but there are lots of handy calculators online that will do the math for you. So mysupportcalculator.ca is a popular free one, and if you plug in all of your information, it's going to give you that low end, mid-range, and high-end amount of support. The ranges can be pretty broad, especially if the couple has been together for a long time or there's a big difference in income between the spouses. So you can start to see why there's often disagreement between separating parties when it comes to spousal support. Just with the examples that I've made up, you might end up on the low end side of things with $500 a month for 5 years, or on the high end with $1,500 a month for 10 years. And that's a huge difference. Often you'll see the recipient or the lawyers for the recipient asking for the high end of the range, while the payor or their lawyers offer the low end. And then if they go to court, the court might opt for the mid-range. However, not only is this not really conducive to settlement, but also the midpoint isn't really meant to be treated as the default outcome. Chapter 9 of the Spousal Support Advisory Guidelines gives a lot of guidance on how to determine an appropriate point within the range, and it sets out a non-exhaustive list of factors that the court may consider when they're making a decision on this. And this includes things like the strength of any compensatory claim, the recipient's needs, the age, number, and needs and standard of living of any children that are involved, the needs and ability of the payor to actually be able to pay the support, work incentives for the payor, property division and debts, and self-sufficiency incentives. So you should be sort of asking yourself these questions when trying to figure out where on the range you should reasonably land, because if you can justify your position, this will be helpful not only if you end up going to court, but also in the preceding settlement discussions. There are a couple of different scenarios where indefinite support may be awarded. The first is if the marriage has been longer than 20 years in length, and the second is when the marriage has lasted 5 years or longer, if the years of marriage plus the age of the support recipient at the time of separation equals or is more than 65. And this is called the rule of 65. So for example, if my partner and I have been together for 15 years, and I'm 55 years old at the time of separation, you would add 15 plus 55, which is 70, which is more than 65, which means that I may be entitled to indefinite support. But you have to be careful here. Just because indefinite support may be awarded doesn't mean it will be awarded if it's not appropriate for your situation. And also, even if you are awarded indefinite support, it doesn't necessarily mean it's going to be permanent. There won't be an end date specified, but if financial circumstances change for either party, then spousal support may still be reduced or terminated altogether. If the payor's income is more than $350,000, then the guidelines don't apply to any income over and above that amount. However, it's also not a cap. So spousal support can and often will increase for income above that ceiling, but it's on a case-by-case basis. And the idea here is really to equalize the financial situation of the parties. A couple of final thoughts here. I briefly mentioned this already, but again, spousal support is secondary to child support. So if child support is ordered, spousal support is going to be at a slightly reduced amount. And also, as I said, spousal support is subject to variation or review if the financial situation of either party changes. For example, if a payor loses their job or retires or otherwise has a decrease in income, or on the other hand, if the recipient has an increase in income. Now, let's talk about taxation of spousal support. Unlike with child support, there are different tax implications for spousal support if it's paid pursuant to a court order or agreement, depending on how that support is paid. So spousal support can either be paid as a lump sum or as periodic payments. For periodic payments, the recipient has to declare that spousal support as income at the end of the year, which means that they have to pay tax on it, while the payor gets to deduct that same amount from their income. For a lump sum payment, on the other hand, there's generally no tax deduction, and usually a lump sum tends to be a smaller amount to take this into account. Now, let's go through some of the pros and cons of each, and I'm going to start with periodic payments. For someone who requires spousal support to meet their basic needs, periodic payments are going to provide ongoing financial stability to the recipient, which is going to help ensure that they have a steady source of income, which can be helpful with budgeting and planning. For the payor, periodic payments create a long-term financial obligation, which may become burdensome over time or limit their financial freedom. However, periodic payments can also be adjusted based on changing circumstances, such as changes in income, unemployment, or remarriage, which provides some flexibility to accommodate the evolving needs of both parties. This might be sort of a pro and a con. So, for example, if the payor loses their job or becomes injured or disabled or sick and they're no longer able to work, then spousal support may be significantly reduced, if not terminated altogether, which can be problematic for a recipient who is relying on that money. Also, speaking of long-term financial obligations, some people just want a clean break from their ex-partner and they don't want to be reminded of them constantly, which is understandable. And having to regularly pay that spousal support doesn't really allow for that. So this brings me to my next point, which is potential conflict. There may be ongoing conflicts or disputes regarding the payment amount, missed payments or late payments, or changes in circumstances that require modifications to the support agreement. And sometimes these disputes, unfortunately, do require further legal intervention or even going to court, which, of course, everyone wants to avoid if at all possible. The other obvious disadvantage of periodic payments, as I mentioned, are the tax implications. As a recipient, if you have a lower income and you're in a lower tax bracket, then maybe it's not a big deal. However, keep in mind that spousal support can be ordered even if the recipient does earn a fairly high income, so long as the discrepancy between the parties' incomes is large enough. So if someone is in a higher tax bracket, a big chunk of that is going to then go towards taxes. On the other hand, a lump sum is not taxable for the recipient, so it means that you have that tax advantage as the recipient. However, as I said, this means that the lump sum is generally a reduced amount compared to periodic payments. Lump sum payment also provides predictability, finality, and closure to both parties because the support obligation is fulfilled immediately. There are no ongoing calculations or adjustments required, and it really simplifies financial matters and eliminates the need for periodic monitoring and potential conflicts over missed or late payments. For the recipient, this means you know exactly what you're getting, and you don't need to worry that there might be a change in the future that's going to result in a reduction or termination of support. Also, since the recipient spouse receives the entire sum upfront, this can give them a lot more financial independence and the opportunity to invest or manage the funds as they see fit. This can also be a negative for someone who maybe doesn't have good financial knowledge or responsibility. They risk mismanaging those funds or making poor investment decisions, which may potentially negatively affect their long-term financial security. It's important to keep in mind here that one isn't necessarily better than the other. It just depends on what makes the most sense for you and your financial situation. If you're not sure, it's a really good idea to talk to a lawyer or even a financial advisor or another professional so you can make sure that you understand the implications and you can make an informed decision on this issue. Okay, that covers spousal support, so let's talk about property division next. Once again, property division works essentially the same way for common law partners as it does for married couples. However, in order for property to become shareable as family property, a common law couple has to have been living together for at least 3 years. Unlike with spousal support, the 1-year cohabitation and a child together is not enough for property division to kick in. This remedy is only available to common law couples who have been living together for 3 years or more. So when parties separate, the property is going to be treated slightly differently depending on whether it's owned jointly by the parties or in separate names. family property and property division are governed by something called the Family Property Act, which is a provincial piece of legislation, but this act only applies to property that is owned by each party individually, not for joint property. The way that property is dealt with in Manitoba is through an equalization of the value of the property rather than actually dividing the property itself. So you look at the value of all of the property that is owned by each person minus any debts, and you only look at the value or the increase in value from the date of cohabitation or marriage, whichever was earlier, to the date of separation. So each party keeps whatever they already have that's in their name, and the one with the higher net position has to pay half the value of the difference in their net positions to the other party to equalize. And you would look at the values as of the date of separation. There are also some exceptions to this, and we'll talk about those next. The first exception is pre-acquired assets. As I said, property is only shareable if it was acquired from the date of cohabitation to the date of separation. So anything that I come into the relationship with, the value of that property is not subject to equalization. However, if there's any appreciation or depreciation on the property, or if there's any income from the asset, that is all going to be shareable. For example, let's say I have a piece of property and the day before I move in with my partner, that property, whatever it is worth $20,000. We live together for 3 years, we're now considered common law, and then we decide to separate. On the date of separation, let's say that the same piece of property has been appraised and it's now worth $50,000. So that initial $20,000, that would not be subject to equalization because technically that's what I came into the relationship with. However, that additional $30,000 in appreciation would be shareable. So this means that I would be entitled to half the value, or $15,000, and my partner would also be entitled to half the value. If I don't have the money to be able to pay that equalization to my ex-partner, unfortunately, I might have to sell that piece of property. There is an exemption to this exemption, though. If the pre-acquired asset was purchased specifically in contemplation of marriage or cohabitation, it is going to be shareable. So for example, let's say you and your partner are talking about getting married or moving in together, and your partner decides to buy a cottage. You talk about how great it's going to be to have the cottage, you'll be able to go there together, and maybe one day you want to have kids and start a family, and you're going to use that cottage for your family. So your partner purchases the cottage and it's in their name only. Maybe they earn more or whatever the case is. And then you go on to get married, you become common law partners, and now you're separating and dealing with property division. The cottage may be shareable even if it's pre-acquired and in your partner's name only, if you can prove that it was purchased in contemplation of marriage or cohabitation. Another exemption is assets that are disposed of by spousal agreement. So this is pretty straightforward, but if you and your spouse have a contract that says a certain piece of property won't be shareable as family property, or it won't be subject to equalization, then it won't be. And again, this would be in like a cohabitation agreement or a prenup or a postnup or something similar. Next, we have gifts, trust benefits, and inheritances from third parties, which are also generally exempt unless they were given with the intent to benefit both parties, in which case it will be shareable. Personal injury proceeds are also exempt, so if you get injured and maybe you sue somebody and you get some money from that, that's yours to keep as well. As I said, joint assets are exempt under the Family Property Act. With joint assets, the way that it works is you would just look at the current value rather than the value at the date of separation, and one person can then either buy the other person out or they can sell the property and split the proceeds. And lastly, liabilities or debts are not going to be included in property division only if they would reduce the party's net position to a negative net position. So if I have $20,000 worth of assets, but $30,000 worth of debt, that would put me in a negative net position at negative $10,000, but that negative debt won't be shareable. My net worth for accounting purposes would just be bumped up to zero. You can apply to the court for a negative accounting to be allowed, but it is very rarely granted. Now, you can also lose an exemption if you're not careful and you convert the property to a joint or family asset. This can happen if you transfer it to joint name with your partner, or even if you intermingle it with family assets, which can result in either partial or total loss of the exemption. So, for example, if I get a big inheritance, but I transfer it to an account with other money in it, that family bills are maybe paid out of, that might constitute converting the asset to a family asset. And of course, this can apply to any of the other exempt assets. So if you want to make sure that the asset is not going to be shareable, it's a good idea to keep the money in a separate account, or if it's a physical piece of property, make sure that it's not used for any sort of family related purposes. So how do we determine the value of a piece of property? Well, you just look at the fair market value. Sometimes in the case of maybe a car, that might be pretty straightforward to figure out. You just look at the Blue Book value. However, with other pieces of property like a home or maybe even a piece of jewelry or something where the value isn't totally clear, you might need to get an appraisal or expert opinion to determine the value. The fair market value is also going to take into consideration any inherent tax that exists in respect to the asset. So, for example, RRSPs that are going to be deregistered or withdrawn are calculated to reflect their marginal tax rate, which is 33%. So, the value of that RRSP for the purposes of property division is going to be reduced by a third. You can also, under certain circumstances, add assets to an accounting. For example, if someone has dissipated an asset, this means that they have intentionally wasted, depleted, or misused the asset without the consent or knowledge of the other spouse. And it's typically done to reduce the value of an asset or to deny the other spouse's rightful share of that asset during divorce or separation proceedings. This can be done through things like excessive gifting or selling something for inadequate consideration, or in other words, for a lot less than it's worth. And there's generally a 2-year limitation period for dealing with an asset that has been dissipated. You can also seek compensation from the third party to whom the asset has been sold or gifted if they were not acting in good faith. So if they knew essentially that they were participating in the dissipation of this asset by taking the asset. You can also apply to court for unequal division of property, but again, the court very rarely grants this. It's only really granted if equal division would be grossly unfair or unconscionable, which is a very high bar. Keep in mind also that there are slightly different rules when it comes to property division for things like Canada Pension Plan or CPP, which is generally shareable after only 1 year of cohabitation rather than the usual 3 years. And as well, employment pensions may have different rules depending on whether they are provincial or federal pensions. And lastly, there are different rules for commercial or business assets, so keep that in mind. Okay, the last topic of the presentation is protection orders and prevention orders, and these are governed by the Domestic Violence and Stalking Act, which is a provincial piece of legislation. Protection orders can be obtained by applying to a Judicial Justice of the Peace, or JJP, at the provincial court. They are common in cases of stalking, harassment, and family violence. And not only can you apply for a protection order for yourself, but you can also apply for one on behalf of a child if necessary. Applications for protection orders are meant to be quick, inexpensive, and relatively straightforward so that the average person can easily apply for one without a lawyer. There is no cost to the party applying, and you don't have to give notice of the application to the other party. So the way that it works is you usually go to the court, you submit your application, and then you wait around for a little while, and your application is going to be heard the same day. You are then going to have to provide evidence under oath about the stalking, harassment, or family violence that took place. In order to grant the protection order, the JJP has to conclude a few things, and all of these boxes have to be checked off for the protection order to be granted. If your protection order is not granted, it's because you didn't fulfill one of these criteria. So the JJP has to conclude that domestic violence or stalking is occurring or has occurred, that there is a reasonable likelihood that it will continue, and that the circumstances are serious or urgent enough to warrant granting the order. Because these applications are allowed to be made without letting the other party know, they are seen as really an exceptional remedy and are only granted in emergency situations. If your protection order is granted, the respondent is going to have 20 days to ask the court to set aside the order if they don't agree with it. And they're also going to have the opportunity to present evidence in court to support their case. Usually, there are a few standard conditions that are included in protection orders, like the respondent cannot follow the applicant, they can't communicate with or contact the applicant, they can't go near their home, job, school, place of worship, or any other place where they happen to be or attend regularly. Protection orders that prohibit these things can, however, allow for exceptions so that the respondent can do things like go to court or mediation or attend at a court-ordered assessment. You can also have other conditions depending on the circumstances. There might be a condition that a police officer can remove the respondent from the residence. The applicant can also be granted temporary possession of necessary personal items, and a police officer can also accompany the applicant to the residence to supervise the removal of personal items. Protection orders generally have an expiration date, and that's usually 3 years after it was granted. Moving on, prevention orders are a little bit different. These are obtained on application to a judge at the Court of King's Bench rather than a JJP at provincial court. And although they are also intended to address family violence, stalking, and harassment, they are generally not intended for emergency situations. Applications for prevention orders take longer than those for protection orders, and they can actually take a few months or even longer to be decided. Both parties are going to have notice of the hearing in this case, and both can present evidence to support their case. Parties can represent if they choose to do so, but it is a good idea to have a lawyer for a prevention order application. A prevention order can include any of the same conditions as a protection order, as well as any other conditions that the judge considers appropriate. For example, they can grant an order allowing the applicant sole occupation of the family residence. They can give temporary possession of specified personal property like household goods or furniture or vehicles. They can seize items used by the respondent to further the domestic violence or stalking. So things like cameras, video equipment, computers, and other recording equipment. They can recommend that the respondent obtain counseling, or they can order them to do so. They can also prohibit the respondent from damaging or dealing with property in which the victim has an interest. They can order the respondent to pay compensation to the applicant for any monetary loss that was caused by the violence or stalking, such as expenses for counseling, security measures, moving or lost income, or any other conditions they deem necessary. A prevention order has no expiry date, so it stays in effect indefinitely or until it is terminated or revoked by a subsequent order. This brings us to the end of the presentation. Once again, I'm going to leave you with some resources here. If you don't have a lawyer but you need some legal information, you can contact CLIA's Law Phone-In and Lawyer Referral Program, and our Winnipeg number, toll-free number, and email address are all on the screen. You can also check out our website, which has a lot of great publications, information, and resources, not just about family law, but about many other areas of law as well. And lastly, I've included a couple of links to government websites, like the Manitoba Government Family Law page and the Manitoba Court website, which has information about forms, procedure, and other court information. Thank you so much for watching. If you haven't seen parts 1 and 2, make sure to take a look at those, and otherwise we will see you in future videos and webinars. Thank you. Bye.